Welcome back, ladies and gentlemen. Mr. Shaw, Miss Womack, back again.
Hello.
We're going to get into 4.4 to 4.7 or 8. We're not really sure. Probably not much 8, but that's okay.
It's mostly through 7. 8 doesn't do much for us.
It was kind of interesting.
It was all right.
Anyway,
Moving on.
Let's do it. So in 4.4, we're going to describe the rights to assemble and associate protected by the First Amendment and their limitations. So there's two parts to the freedom of assembly. It's the right to assemble and the right to associate.
All right, so right to assemble first. The literal right to assemble, that's what the First Amendment covers, is our ability to gather in groups. Assemble. Now.
Like the Avengers.
Yeah, Avengers assemble. So, time, place, and manner can be restricted. Okay, for example, most of the time if you are going to assemble in some way in a public area, you probably have to get a permit from a local city government, just depending on where you're living or where you're deciding to assemble at. You have the right to protest. Now, it has to continue to be peaceful. It cannot be violent or anything like that. And an example of this, and obviously protesting cannot get to the point of harassment. And so the example your book gives talks about pro-life protesters who are seeking to shame or harass clients that are going into, let's say, a Planned Parenthood, for example. And the courts have addressed this situation. They have aimed to restrain these kind of harassments or these people who are seeking to shame others, and they set limits on how close these protesters can actually come to the clinics.
And even what they can do.
Yes.
Like they have to leave space. Like there's people who would try to block women from going into abortion clinics, and they have said that you are once you start infringing upon other people's rights, that is where you have to draw the line.
Yep.
The time, place, and manner restrictions were really interesting to me though. I growing up, I never really thought about it like that. They're yes, you have the right to assemble. Congratulations. However, you're going to do it when we say.
Yeah.
I don't know.
Remember, all of our First Amendment rights have limitations to them.
True. All right, let's get into the right to associate. So the right to associate is kind of a extrapolation, I guess, of the freedom of assembly. And what it means specifically is that you have the right to join any group that you want. And basically that can't be restricted in any way. So, for example, in the Civil Rights era, the Alabama state government was looking to discourage people from joining the NAACP. And so they asked the NAACP for a list of their participants and people who had joined the group. And in the Supreme Court case, they decided that Alabama couldn't do that, specifically because that would have violated people's right to associate. Also kind of right to privacy, I feel like.
Yeah.
I mean, you have to make sure that, again, you can't be harassed. It's kind of for depending on how you voted, you really can't be harassed for that, even though it is kind of public record.
Yeah, I mean,
but who's going to look that up?
I think they're just covering that we have the right to associate, for example, with a political party. We have the right to be Republican, or we have the right to be a Democrat, and the government can't really infringe on that.
Correct. And again, and that their membership lists are protected. So again, the only way I guess you could be criticized for that is if you had shared that information with somebody. The last thing about the right to associate that has popped up from time to time, it's more of an example, is that it's like a military recruiters. So there were some law schools that were arguing that they should not be basically requiring people to have military recruiters at their school. They said that violated their freedom of speech. And they ruled that the public schools cannot prohibit them because they are a government entity, and it's not like they're forcing them to... That
people can ignore the recruiters who are there. They don't have to engage with them.
Exactly. But again, since it's a government... both of them are government entities, they cannot physically stop them from doing it. But again, they can choose where they set up, things like that. Right. So they might be able to put them in an area that's not very high traffic.
Yep. All right, moving on to 4.5. Describe the right to bear arms protected by the Second Amendment and its limitations. So we've moved from the First Amendment to Second.
This shouldn't be controversial at all.
So the right to bear arms. Actually, Mr. Shaw, it is super controversial.
Oh man, I'm wrong a lot lately.
So we're going to kind of talk about the Second Amendment. Is it subject to national, state, and local restrictions? So who has the authority to restrict our right to bear arms or own guns? At some point, the states and local governments are going to come in and start issuing background checks. They're going to limit sales for certain types of guns, etc. President Trump actually passed an executive order banning bump stocks.
He did.
Recently.
He did.
Yeah.
And that was the bump stocks were the ones that were used in the Las Vegas shooting.
Yes.
At the concert, I believe, was that one?
Okay, anyway.
Sorry.
So where am I going with this? So anyway, at a national level, we have the right to bear arms. However, depending on where you live, there may be different restrictions or different requirements when it comes to actually having access to those firearms. And then moving on to the NRA, we know the National Rifle Association is probably the biggest interest group in the country. And they have a lot of members, and they use money to kind of fight gun control measures, especially when it comes to Congress. And so they're constantly lobbying members of Congress to pass laws that are going to limit restrictions on gun control. And they've been pretty successful in the last 20 to 30 years with their lobbying attempts.
I mean, you throw money at something, it's bound to change.
Right. And then the question comes up is, what were the framers' intent when it came to writing the Second Amendment? So we kind of learned that at the time period in the late 1700s, each state had their own militia. And so they put the Second Amendment in there, and it says, every person has a right to bear arms. Well, that's because if there was an attack on the country, they wanted citizens to be able to form a militia very quickly in each state. And so now that we've progressed through history, we take it in modern day times as we have the right to keep and own a gun.
In self-defense. And
we should use it in self-defense, yes. So, again, I think that's maybe the root of the issue is, what was the framers' intent on adding the Second Amendment? Is it for individuals? Is it for militias? What is it? But we use it right now, and the Supreme Court says now that we do have the right to own a gun, and in general sense of the terms, for self-defense or for defense of our property or family or whatever it might be.
What's interesting to me about it, too, is that we have kind of, originally they wanted this to have the state militias just in case the government kind of got out of hand.
Right.
We had just, freed ourselves from the rule of Great Britain, less than 20 years before the Constitution was ratified. So they were really worried about an unjust government, somebody like some president taking over, or some unqualified congressman taking over and starting to kill people in America, and they wanted the citizens to be able to defend themselves. Right. And if the government did that nowadays, I mean, there's nothing we're doing about it. They're going to have some drones, sniping us out of the sky. On to happier notes, though. Anyway, so the Supreme Court actually did rule that it does apply to the actual right to bear arms. It is not just about militias. They have decided that in the past. Right. I don't remember what the case was, but it was something specific that has allowed you and people to bear arms.
Correct.
Continuing that just a little bit in the district.
It's that one.
Oh, look at that.
It's right there. District of Columbia v. Heller.
Look at me go.
Oh, wait. Do you want me to go?
No, I got it. It's okay.
2008.
Sorry. So in D.C. versus Heller, that was the case I just mentioned. The Supreme Court protects an individual's right to own a handgun, and it is lawful to use a handgun for self-defense purposes. But again, obviously, it's not going to be okay to just go around and use your gun, especially if it threatens other people's freedoms or life.
Yes.
Okay. So McDonald v. Chicago is a required Supreme Court case. We're not going to get into it a whole lot in the video, but we will talk more about it in class. What you need to know is that in McDonald v. Chicago, it extended the individual's Second Amendment rights, which specifically it incorporated it into the state. So like we were talking about incorporation doctrine in the last video, the Second Amendment was finally incorporated into that it actually does apply to state governments as well in McDonald v. Chicago in 2010. Seems like I'm surprised it took so long.
I agree.
Anyway, again, so that specifically limits state and local gun control laws, and so now kind of the state and local localities are trying to fix that and kind of trying to repair these laws. Like Missouri now it's pretty much open carry without like background checks and stuff like that. I mean, Missouri is one of the most liberal as far as
unliberal laws.
I don't know how to say that.
I don't either.
I'm not even going to try.
But it's very easy to own and possess a gun, to purchase, own, and possess a gun in Missouri. And there are states who have much stricter laws than we do.
Seems good. All right, so we're getting in the meat and potatoes now.
4.6 already.
Let's do it.
This one's long.
It is.
Characterize defendants' rights and identify issues that arise in their implementation. So, once we get into the middle of the Bill of Rights, we're going to get into, oh my God, we're going to get into Amendments 4, 5, 6, 7, and 8, and those are all put into place or designed to protect the rights of those being accused of a crime.
Correct. So everything before is for everybody, but not everybody's going to be accused of a crime in their life. So now, from here on out, 4 through 8, we are going to be covering the rights of the accused. So let's start off with search and seizure. What I would do if I were you is I would actually go to your book for this one, because this one's
hard to see.
A little bit hard to see. But again, this is gonna kind of guide you through every step of the way, and it shows you. It's like they call this the funnel of like the criminal justice system. And so you start out when you're accused of a crime, and then it goes all the way down to where you go to trial, and then you're found guilty or innocent. I don't know. It
gives you the protections along the way, so you can kind of connect. Well, this is where the Fourth Amendment would apply. This is where the Sixth Amendment would apply. So it might be good to just look over this and be familiar with it.
It wouldn't hurt. So that's up to you guys, though, because we're going to go over all this anyway.
Yeah.
All right. Go ahead.
Sure. Search and seizures is first, and under the Fourth Amendment, you are protected from unlawful searches and seizures. The law or the Fourth Amendment requires police to have probable cause at least, meaning they have to be reasonable grounds for believing that you are guilty of a crime. Okay. Most of the time, law or, authorities, police, officials are going to have some type of search warrant, and that's something that's going to be written and authorized by usually a judge or a court. And it's going to give specifics on what they can search you for, or what they can search your house for, or your car, or whatever it might be. In some cases, sometimes we see cases that come up that the law enforcement officials had a warrant for one specific thing and they obtained something else in the warrant, and that usually is deemed illegal or unconstitutional, and they can't use that in court.
So real quick, is that the Fourth Amendment has numerous exceptions, and I would definitely be familiar with it. That one is one of the questions on the quiz. So for example, like yes, you need to have the reasonable suspicion, but sometimes if, like, for example, a police officer is found to have been fearing for his life, they can ask you to vacate your car and they can search for a weapon, and just to ensure that, again, it's for their safety. Other things that might fall under there is, like, if you are seen like possibly like swerving as you're driving, they do not need a warrant to have you take a breathalyzer test. And that's but if they were going to do like a blood test, they do need a warrant for that. So there's a lot of
that's where we go back up to that first bullet where it's probable cause. If a police officer has probable cause to think that you are under the influence and driving, they don't need a warrant to stop you and give you some type of sobriety test.
Right. And there's a lot of other things too. A lot of people think that this is unfair. And we'll talk about the exclusionary rule. Actually, let me just talk about that real quick, and then that will make sense.
Yeah.
For some of the other exceptions. So the exclusionary rule, it prevents evidence from being introduced in a court if it was obtained illegally by police. So Mapp versus Ohio was a really famous case. There was a woman, her name was Mapp. Dalry Mapp.
Dalry.
And she was they searched her house looking for like a bomb suspect, I believe. Something like that.
Fugitive.
Yeah, some sort of fugitive. And they found pornographic materials in her house. And they arrested her. This was in Ohio, obviously. So they arrested her for violating an anti-pornography law. And she sued, saying that her rights were to unreasonable search and seizure was violated. There was no warrant for that. The warrant was for the fugitive. Anyway, they ruled in favor of MAP, and that led us to the establishment of the exclusionary rule. That evidence was obtained illegally, therefore it cannot be used. But if there's a weird thing that they do is that if it's not necessarily obtained illegally, if they didn't intend to obtain something illegally,
Right.
it was just like negligence. That sort of evidence can still be used.
Yeah.
So that's really weird, and we have these like the court is like trying to figure out what evidence it can use and not use. But there's a lot of people that think that this is kind of unfair. It leads to guilty people who are getting off scot-free because of a technicality.
Right. But just like, and I tell my classes all the time, in all of these cases, in all of the whole Bill of Rights, it's very gray. The Supreme Court decides differently on all these different situations, and it's not a black and white situation. There's always a bunch of gray area in between these decisions.
Correct. Okay, I can finish up.
Sure.
So the war on terror really changed everything after 9/11. I think a few weeks after 9/11, they passed the USA Patriot Act. Do you know that's an acronym? The Patriot
No.
Act? Yeah, it's an acronym.
Well, what is it?
I don't know what it is, but it's
Okay.
but it is an acronym. Anyway, we'll talk about the acronym later. This was passed after 9/11. It allowed the government really broad powers to engage in wiretapping and surveillance when investigating terrorism suspects. Guys, this completely throws a lot of the Fourth Amendment out the window, especially if you were a foreign national and you were on our radar for being a terrorist. And a lot of people felt that the Patriot Act was absolutely unconstitutional, and they had a good argument, to be honest with you. But like we've said before, in times of crisis, our rights are really fluid, and that was really what the Patriot Act showed us.
Yeah, I mean, the government was trying to, they were just making attempts to try to catch terrorism, be ahead of the curve or whatever you want to call it. But by doing that, did they invade severely on our Fourth Amendment rights?
Well, and they
Probably.
wiretapped our phones. Like they forced like cell phone companies to keep records of calls and texts and stuff like that. And sometimes they would like without warrants, they would just go into those companies and get that information illegally in the fight against terror. So that we'll talk more about that in class, because I think that's a really interesting thing that you guys will probably have a lot of questions about.
Yeah. All right, so moving on to self-incrimination. The Constitution itself, or the Fifth Amendment, actually says no person shall be compelled to be a witness against himself. So this is in regards to if you are charged with a crime and you're going to be, let's say, in a court case, right? The Fifth Amendment says that you do not have to be a witness against yourself. You do not have to testify against yourself. So when you're listening or you're watching TV or movies or whatever, and you hear I plead the Fifth, that's just somebody saying, I'm not going to answer your questions. I'm not going to incriminate myself by answering your questions. And you completely have the right to do that. So the burden of proof is actually put on the prosecution. The prosecutors, the people who are charging you with a crime, they have to prove that you are guilty. Correct. And you don't have to say anything in that regard. So you've probably heard of this case before, Miranda v. Arizona. It happened in the 1960s, and it basically establishes your Miranda rights. So again, if you're watching TV and you see someone being arrested and the police officers are reading off the Miranda rights, you have the right to remain silent. You have the right to an attorney. If you cannot afford one will be appointed to you. Those are your Miranda rights, and we get that from a case where someone, an immigrant, was arrested for, I think it was murder,
rape and kidnapping,
and he did not fully understand his rights as someone accused of a crime, and he was not actually read his Miranda rights. He falsely incriminated himself by signing a statement.
Not false. I mean,
it might have happened. He did it. But the point here is that the police, when arresting you, have to be very upfront with what your rights are, and they have to make sure you understand them. Okay, so you have the right to remain silent, knowledge that what you can say can be used against you. Those are all four of those bullets are the actual Miranda rights that we are read when we are arrested.
Ironically, Miranda was later killed, and the suspect was read their Miranda rights. That's a gruesome story, but
I didn't know Miranda was killed.
I appreciate
but I
the
knew
irony.
his case was thrown out because the police did not go through the proper procedures.
And that's why you see them, they have to do it. And I think it's within, they have to read them their rights as long as the interrogation has not started.
Yep.
So even if you get arrested, they could wait, hours until they were ready to interrogate you. And then as long as they read you those before the high pressure interrogation started, you'd be fine. Or they would be covered, I guess.
Yeah.
All right, so the next part is the right to counsel in trials. Again, we're getting into the Sixth Amendment. The Sixth Amendment, the main part about it is the right to an attorney. And a really famous case known as Gideon v. Wainwright, they decided that the state must provide an attorney for indigent, meaning poor or needy people. So basically anybody who can't afford one. What's interesting about Gideon is that he was actually in the wrong place at the wrong time. He was accused of like trashing this bar, and so Florida had a law that they did not provide lawyers for people who in I think civil cases.
Yeah,
or no, it was under a certain amount.
Florida state law was that you're only provided an attorney if it's for a capital offense.
There we go. Okay, so in cases where you might die, okay, based on you might be executed if you're found guilty, then you could have a lawyer. But anyway, he went to prison, and then he petitioned his case to the Supreme Court. They agreed, and they ruled in favor of him that they have to provide you with a lawyer even if you can't afford one. The other thing is about the writ of habeas corpus. If you are arrested, you have the right to be brought before a judge. Basically, this is that you need to know why you are being held. You have to be charged with something in order for them to hold you. You also have the right to a speedy and public trial by an impartial jury. And that impartiality is really important. Like, so for example, if you are like Hispanic and your jury has to have at least some representation of Hispanics on that jury because they would be sympathetic to you. They might understand your situation. But whereas if it was all white or if you were male and it was all females, like that's not necessarily fair. That's not representative of the population as a whole. And that's kind of what we saw during the civil rights era. There was a lot of there was black people being accused of crimes against white people, and their juries were all white. Mm-hmm. And that's not going to end well for the black people that were accused of the crimes. And what does speedy mean? Like they never really talked about that,
because some court cases take literally years. I mean, to get to court and to actually get the case going, it can literally take years. And so the Constitution does not specify what is speedy.
Right. And that's part of the problem that judges face in trying to set these times. So some people could actually sue that their trial wasn't speedy enough, and that might have led to their incarceration, or maybe they could sue for damages or something.
Right. All right. The right to counsel and trial. So your book brings up a term. It's called plea bargaining. And this is just kind of an agreement between a defendant and a prosecutor so let's say the defendant would plead guilty to maybe a lesser charge, and then the prosecutor in exchange will give them a lesser punishment. And this kind of connects with the whole speedy system. This is going to make things go a lot quicker. If you are in a messy court situation and the prosecutor says, well, instead of charging you with murder, we'll charge you with manslaughter, and instead of 30 years in prison, we'll give you 15. You're going to be like, yeah, I'm cool with that. Let's take that deal. It's a plea bargain. Okay. And a lot of cases end in a plea bargain or a deal instead of actually going through the full court case.
And that's good for both sides too, because it's like these cases are really expensive, so it's less money for the state or the federal government, and it's a better deal for the person. Some people don't like that. They like that.
Yeah, some people feel like they're being forced to plead guilty to something that they're not actually guilty of, but they're worried about if they do go to court, then how would they do against a jury? I don't know. It's a whole situation. Anyway, normal size of a jury is going to be 12 people. And convictions, not all convictions? I thought it was murder convictions.
I think it's, I think in criminal cases.
In criminal cases. Okay. In criminal cases,
must be unanimous.
The jury has to make a unanimous decision. So all 12 have to agree. Detentions in the war on terror. So after 9/11, again, 9/11 really throws a wrench in some of our liberties. But after 9/11, the FBI is authorized to detain thousands of people, 1,200 people, as possible dangers to national security. So maybe they're terrorism suspects. This situation actually goes to the Supreme Court, and the Supreme Court says that the government was unlawfully detaining these prisoners, and that foreign terrorism suspects actually, even if they are suspected of terrorism, they actually have the rights that are given to us in the Bill of Rights. They also have access to those rights. So they can actually challenge their charges in a U.S. court. And so the book just brings this up as something important for you guys to know.
Sure. Well, and
everyone has the right to our Bill of Rights if you're in the United States. Legally.
Well, I would assume so. I mean,
yeah, it's not just citizens. It's anyone in the United States. Our constitutional rights extend to you even if you're not a citizen of the United States, but you're in the United States.
What about like if you were here illegally?
I don't know.
I don't know either.
Gray area.
That's another gray area.
Gray.
Again, so that these prisoners in Guantanamo Bay, they were not given they were not given basically it was ruled as cruel and unusual in a lot of ways, but also they were not they were not allowed their habeas corpus rights. Nobody knew why they were there. They weren't told why they were being charged. They weren't allowed to have a jury trial. Some of them were just sentenced.
Mm-hmm.
Some of them weren't even at their trials, their quote unquote trials that they had.
Yeah.
So there was a lot of issues going on here. But again, remember that when in times of crisis that we
bend the rules.
We have no idea what's going on, and we do what we think we have to. All right, so going back to cruel and unusual, that is the Eighth Amendment. So again, this protects you against cruel and unusual punishment, and unfortunately, cruel and unusual is not defined. We don't really know what that means. The cruel and unusual part of the Eighth Amendment, though, was incorporated in 1962. To give you an example, in 2011, California was forced to actually release prisoners because the conditions were deemed cruel and unusual because there were far too many prisoners in these prisons. So they were forced to release them in 2011. Gregg versus Georgia in 1976 is a monumental case because it actually ruled that the death penalty is not cruel and unusual. And so we've seen a lot of issues with that. A lot of states don't think that that any sort of death penalty should be allowed, but they still have a lot of autonomy in determining that in their state. But you'll see, again, I think Texas has like over half or almost half of all death penalty cases or all executions are from Texas.
Missouri has the death penalty.
That's true.
The United States is one of the last developed countries to still implement the death penalty.
You sound upset about that.
No, I'm just saying. I'm just giving you facts.
Oh, okay. Well, I appreciate it.
You're welcome. The Supreme Court says it's fine.
That's true. And who are we to argue with them?
Not me.
Anyway, the last one that we wanted to talk about was McCleskey versus Kemp. This is stated specifically that the death penalty does not violate equal protection of the law guaranteed in the 14th Amendment. And what's interesting about that too is that the juries do not intend to discriminate based on race. So what the problem here is that more African Americans or a higher percentage of African Americans are incarcerated, and so they are
and sentenced to death.
And sentenced to death. Sorry, thank you.
Yeah.
So what's important about that is that they are suing now, stating specifically that it is a cruel and unusual punishment specifically for African Americans because they are incarcerated and executed at a higher rate than other races.
So they argue that their 14th Amendment equal protections are being violated because they're not being equally protected under the law.
Correct. Right?
They're being discriminated against in that regard.
And in this case, they decided that the juries are not intentionally discriminating based on race. Again, the jury specifically, they just are deciding on the case. It wasn't like they said, hey, go commit a crime.
The defendant has been brought before the jury. It's not like they're picking out someone and saying, you're black, we're going to put the death penalty on you. It wasn't like that. So, yeah.
Although that is still a huge problem that is really not being dealt with, unfortunately, in America. Anyway, on to happier things. Again, you have seen. Hey, this was in the book. So again, you see, and this is just in Texas. The pink is just in Texas, and the blue is everywhere else. You see how much Texas actually has. But you have seen, as a whole, executions have gone down significantly over the past 20 years.
I wonder what the cause of such a sharp increase In 99.
Y2K?
I don't know. They don't even know what that is.
They don't know what that is. It's okay. Again, I would imagine that like as we've gone closer to our time, a lot of people are still kind of there. We're seeing a really big decline in people just wanting death penalties in general. They are usually more people now are against the death penalty than we've ever had before. But again, look in the 80s. Like, what the heck's going on?
I don't know.
I wonder how. Again, it's interesting. I would want to see the rise the crime rates. And
Okay.
compare this to the crime rates. I think that would be a better graph.
I agree.
Unbelievable.
All right. Objective 4.7.
Last one. Let's do it.
Outline the evolution of a right to privacy and its application to the issue of abortion.
This is going to go well.
So, do we have a right to privacy? I think we probably do. Under the 9th Amendment, we have more rights than what are listed.
Well, and even the 4th Amendment, too. Like, it says that there's no searches and seizure, no unlawful searches and seizures. So that kind of creates a right to privacy. Mm-hmm. We're getting into it. So the last thing, we're also going to cover a controversy over abortion. Take it away.
Okay. So is there a right to privacy? How is privacy implied in the Constitution? Well, according to our freedom of religion, our freedom in the First Amendment, we have the right to exercise our own private beliefs. Obviously, we have freedom to do that. And Mr. Shaw talked about the Fourth Amendment guaranteeing us a right from unlawful search and seizure. Again, that's a right to privacy in your own home, in your own car, whatever vehicle you might have. And we also have the right to be left alone. I don't really know how to further explain that, but I have the right to be left alone. Leave me alone.
The way the book puts it, it's like literally you have the right to go about your business undisturbed.
Yeah.
And I don't even...
It's funny that we have to clarify that.
I literally have no idea how to explain that.
So in the 1960s, there's a court case, Griswold versus Connecticut. This is not required.
Not required.
But it is important for you to know. There was a husband and wife that were using oral contraceptives, which is basically like birth control, and because they weren't ready to start a family yet. And I don't know how it got to a court case, but the Supreme Court, it goes all the way to the Supreme Court.
I think they broke a law. They broke a law against contraceptives in Connecticut.
Yeah, but how did law enforcement figure out that they were using contraceptives?
I'm not sure.
Okay. So anyway, the important thing here is that the Supreme Court says that it is our private decisions as a husband and wife to plan a family how we want to be able to plan it. So using contraceptives to prevent pregnancy is perfectly fine under our rights as Americans. Okay? And the court just basically says that the right to privacy is implied in this case.
And you got to remember that in the 60s, it was a really liberal court.
Yeah.
And this was alarming to conservatives. So conservatives are saying they are the court is just making up rights now. There's nothing that they're doing. This is clearly not in the Constitution. And so especially originalists are going to be very upset at this decision because the right to privacy is not listed in the Constitution. They would never have, thought that the founders intended to have it. And so this is definitely a huge case of judicial activism and trying to.
Oh, nice connection.
I try.
Yeah.
Anyway, moving on.
No, I'm not done.
Oh, I'm so sorry.
Wait, what was I going to say? I lost it. I lost the thought.
That's okay. Griswold v. Connecticut. If you think of it, we'll come back.
Okay.
All right, let's do it. So here's the big tuna of abortion. There's a huge controversy, and the main reason is because of Roe v. Wade, which was in 1973. So there was a woman. She went under a pseudonym for this because she wanted to have an abortion. She also didn't want to get killed by people who were pro-life. So she used the name Jane Roe, and she wanted to have an abortion. There was a Texas law banning abortion unless it was to save the life of the mother.
Correct.
So they couldn't have any abortions at all unless it was in that case. She sued, and did you know that she actually had the baby? Isn't that weird?
I did, and that later she came out and was like,
yeah, isn't that weird?
I'm against this.
Sorry, anyway. So she prohibits or what this says is it prohibits state bans on abortion only during the first trimester. And so they argued that during the second and third trimester that the baby is in a higher development. So second trimester, I believe it's more about the mother, and then they can. So if the health of the mother is in question, then there's still other things you can do. But by the third trimester, the baby is almost fully developed, and so states can still limit a woman's ability to have an abortion in the second and third trimesters, but not the first.
For those of you who don't understand what trimesters are, a woman is pregnant for 9 months, which breaks it down into thirds, right? So the first 3 months, the second 3 months, the third 3 months. The first 3 months is the first trimester, and that is where the Supreme Court says no states can ban abortions in the first trimester. The second and third trimesters are where there are many more restrictions on what states can do, or restrict a woman's rights to an abortion.
I always thought it was weird because some women don't know they're pregnant, like even up to upwards of like 2 months.
Yeah.
So anyway, so there's this huge balancing act that has to happen now. Is we're balancing the state interest in protecting women's health, and we're also balancing the state interest in protecting prenatal life. And guys, we're not going to be able to come to a consensus. It's not possible. This is probably the most highly charged issue in America, maybe a close second being gun control. So that's the problem. So you need to know Roe v. Wade is not required, but I would not be surprised.
Yes, it is required.
Is it required?
It is required. Let me show you my chart.
We have visual aids.
Point it out.
There it is, right there.
Roe v. Wade.
Sorry, Roe v. Wade is required. My mistake. So again, you will need to know what it is. It's very important to know that, again, it's just the first trimester that they are prohibiting states from banning abortions during the first trimester.
Planned Parenthood v. Casey.
So what it's going to do is, remember from our last video that we talked about strict scrutiny. So they used to do strict scrutiny on all abortion cases specifically because of discrimination or that certain rights were violated. And so it was very difficult for them to prove when. So basically, if a case goes under strict scrutiny, the state has to choose, or the state or the federal government has to show specifically that it was the easiest way to get the law was the easiest way to get to it, or whatever goal they had, and that it didn't. What's the other thing? I forgot it. That it's the easiest way to get to it. Oh, and that it was absolutely necessary.
Yeah,
that was it.
Yeah.
Okay, so they changed it from strict scrutiny to undue burden. What this is going to allow is it's going to allow a considerable amount of restrictions and regulations on abortion. Yeah. So before, when it was under strict scrutiny, it was very difficult for them to put regulations on a woman's right to have an abortion. But once they change it to undue burden, it's much easier, and that's why you'll see states like Louisiana, some states like in Texas, there's only one abortion clinic in Texas,
Missouri,
and in Missouri as well. We're a very conservative state, so they make it very difficult. And I think the only abortion clinic in Missouri right now is in St. Louis. So if you're across the state, I mean, you have to travel across. So again, it's like you're putting this burden on a woman to get an abortion, and that is theoretically against her rights. But they're saying here that it is a state's states do kind of have that ability to put those restrictions on a woman.
Yeah, and depending on what state you're in, there's different regulations. It's just like guns. There are more restrictions in some states and less restriction in others. In some states, they require, if a woman goes to a clinic and says she wants an abortion, they require a wait period. They require her to come back 24 hours later to actually have access to it. The doctors are required to give her all of this very graphic material and show her exactly how the abortion will be performed. In some cases, if you're under 18, you're forced to tell your parents and get parental consent. At one point, if you were a married woman, you had to get consent from your husband. And so all of this Planned Parenthood case opens up a floodgate kind of for states to be able to keep putting more restrictions on abortion and how much access women have to it.
Wow. That was a lot.
Sorry.
You did a great job.
I have background knowledge.
And you have a lot more than I do, which I'm glad you're here. So, all right. So this is just the last part, I think. Do we even
kind
have
of a wrap
here?
up?
Yeah, so there's a couple things to end up here, guys. We're talking about civil liberties here, and just kind of what this kind of wraps up everything from Chapter 4. Specifically, first of all, with democracy is going to depend on the freedom of expression. We're really democracy can't really exist without that. You have the right. You need to be able to vote. You need to be able to express yourselves and your political beliefs, and democracy really dies if we don't have that. But we have to make sure that a couple things are still happening. You need to have access to information. So you need to have, in order to make informed decisions, which kind of gets us into freedom of the press. We have to make sure we're protecting majority rule versus minority rights. Again, if majority rule is how democracies operate, but at the same time, we can't just limit the rights of the minority. Again, it goes back to Chapter 1.
Yeah.
I mean, this is how a democracy works, but again, some people are always going to be in the minority. We need to make sure they are protected. And also, elites are also going to protect minorities. A lot of people, we're talking, this is going back to pluralist versus elite model. My goodness. Again, this is really important to know that we have a duty to make sure that all American citizens have equal access to, to their rights, again, based on the 14th Amendment now.
Equal access to pursue life, liberty, and the pursuit of happiness.
And that's always going to be hard. And that's the struggle that we have.
Yeah. So moving on to, liberty and individualism prevail. Liberty always prevails. Does it?
I mean, we are more focused on liberties as
Yes.
Americans,
Yes, we
and
are.
individualism.
Right.
But again, those are things that are necessary in our government.
And that brings to the second bullet. We can't hide from vast government. We in the United States, our government is huge. Our federal government plays a big role in our day-to-day lives. So technology enables more intrusion by them. I mean, we talk about the Patriot Act, and that is exactly, it's directly connected to that. And an irony that more government is needed to provide more protection. So yeah, the government does have to step in and put in regulations and restrictions on what some of us can and can't do to provide protection for the good of society, or to provide national security, or to provide equal opportunity for every race of people in the United States. So government is needed for liberty.
Most people think that the less government you have, the more rights you have. But we've gotten into this new era where it really is almost the opposite. You want to make sure that your rights are protected, and you need a government that is big enough and powerful enough to ensure that your rights are protected.
All right.
Guys,
Woohoo!
It was great. Thanks for hanging out. We'll see you next time. Take it easy.